welcome. My name is Lisa Brown. I'm the Executive Director of ACS, and on behalf of ACS, I want to welcome all of you this evening. I think while there were many closely watched cases last term, I think everybody will agree that there was none more significant than Hamdan v. Rumsfeld, both for what it is going to mean for how we fight the war on terror and for what it says about the meaning of our system of separation of powers in this wartime. It's also interesting, I think, in terms of what it reveals to us about the Roberts Court, even as Chief Justice Roberts himself recused himself from the case because of having ruled on the case below. And I think, as all of you know, the court ruled that Congress had not authorized the administration's ad hoc military commissions to try Guantanamo detainees, that Common Article 3 of the Geneva Conventions does indeed apply to detainees, in the war on terror. And most broadly, in the words of Justice Stevens, that the executive is bound to comply with the rule of law that prevails in this jurisdiction. Well, as I'm sure all of you know, this opinion has led to possibly even more questions than it actually resolved. And we have a terrific panel this evening to help clarify the opinion and hopefully tell us exactly what it is going to mean going forward, and sort out the variety of issues that have arisen as Congress and the administration have jumped quickly to try to respond to the court's decision. And to moderate the panel, we have Professor Catherine Powell, who is an associate professor of law at Fordham, where she's co-faculty director of the Crowley Human Rights Program. She's uniquely equipped to help walk us through this discussion this evening because her scholarship focuses on the dynamic relationship between internationalism and constitutionalism. And she, prior to going to Fordham, Professor Powell was the founding executive director of the Human Rights Institute at Columbia, where she was a faculty member and also ran a human rights clinic. And before that, an attorney at the NAACP Legal Defense and Educational Fund. Professor Powell also serves on the board of Human Rights Watch and chairs Human Rights Watch U.S. Programs Advisory Committee. She's a former term member of the Council on Foreign Relations and is a founding member of the U.S. Human Rights Network. So, Catherine, thanks.
Thank you so much, Lisa, and thank you to the ACS staff for organizing this panel in such a timely way, and for all of you for coming out so enthusiastically this evening. I'm going to introduce our distinguished panelists and also just pose some opening questions to sort of frame the panel. We want to leave plenty of time for discussion, and Justin, who is in the back right there, is going to be passing out note cards for you to write down your questions, and we want to leave plenty of time for that. So we're very honored tonight to be joined by three very distinguished panelists. We're going to start with Walter Dellinger, who is the Douglas B. Maggs Professor of Law at Duke University. He also is a partner at O'Melveny and Myers. I'm not quite sure how he does both. He's left
Not very well, actually, is the answer.
He's left the Academy from time to time for tours of duty in government. In 1993, he was a White House advisor to the President. Later that year, he was nominated and confirmed as the head of the Office of Legal Counsel. During the 1996-97 term of the Supreme Court, he was the acting Solicitor General, where he argued a record number of cases before the Supreme Court. When he was head of the OLC, he wrote opinions on a variety of issues, including the President's authority to deploy troops to Haiti and Bosnia, as well as whether the President may decline to to enforce statutes he believes are unconstitutional, an issue I believe we will hear more about this evening. He's published a variety of articles in journals such as the Harvard Law Review and Yale Law Journal, and has testified before several committees of Congress. We will then hear from Hardy Vieux, who is an associate at Robbins, Kaplan, Miller, and Cerezi. He is also and he's over here on my far left, he is also the Secretary-Treasurer of the National Institute of Military Justice. He was previously a Navy Judge Advocate in the Navy Judge Advocate General's Corps, where he was a criminal appellate defense lawyer. He is a member of the Supreme Court Bar, among several other bars. And then Our last speaker is David Rifkin, who is a partner at the Washington office of Baker and Hostetler. He's a visiting fellow at the Nixon Center, a contributing editor to the National Review, and a member of the UN Subcommission on the Promotion and Protection of Human Rights. And in his spare time, he writes op-eds for the New York Times, the Washington Post, the Wall Street Journal, and is a frequent commentator on CNN, Fox News, NPR, BBC, to name but a few. He's also a member of the Council on Foreign Relations. So we are going to start with Walter Dellinger. I believe they will each make some brief opening remarks. Let me just pose two questions for the panel to frame this. I'd like you to reflect a bit on the significance of the Hamdan decision, and particularly given that Walter Dellinger said on the day that it came down on June 29th this past year that Hamdan is simply the most important decision on presidential power and the rule of law ever. So I'd like the panelists to reflect on the significance of the case, and also what can or should Congress do in the aftermath of Hamdan now that the ball is in effect in their court. Walter Dellinger.
Thank you. I would like to put this in a broader context, mention Hamdan, and then refer to the subsequent issues. I think the larger question is, when is the president obligated to comply with the law in areas of national security? To what extent may Congress cabin or regulate or direct the president in the exercise of those powers? And that has spilled from Hamdan into a very intense public debate, to which we will return, I think, after we've all digested Hamdan and the effects on the military. And that new public debate is over the use of signing statements, just recently condemned by the American Bar Association Task Force. It's scheduled to be voted on by the House of Delegates in about 10 days at the annual meeting in Hawaii. And the subject also of new legislation outlawing signing statements, I think, by or at least subject them to judicial review by Senator Specter. But let me start with Hamdan. There was a range of opinions about how significant Hamdan is or I'm out there, I think, with the high bid. Is that, I know, his voice activated. Maybe that's the, I can always stand up and I can be heard, at the White House if I want to be, without the miking. Let me defend the proposition that of the importance of Hamdan. I'll begin with the following question, which was asked me within a week after the tragic events of 9/11 at a forum at Duke. The question raised was, what will the Supreme Court do in light of this extraordinary terrorist attack about the balance between liberty and security? Will it change? And my response was that every question will be two questions. One question will be, how should we adjust the balance between liberty and security? And the other question will be, who is going to make the determination as to where that balance will lie? And that I thought that the Rehnquist court would be willing to make adjustments in the direction of security and away from liberty, and to that extent would move in a conservative direction, but that they would not give up on the question of who gets to decide where that balance will be struck, and that efforts to operate through unilateral presidential authority would not be met by this court with favor. So I think that's the larger context. The argument that Hamdan is not as significant as I have said is best summed up by the statement that it is, first of all, not a constitutional decision, and secondly, at most, an application of the principles of the Youngstown steel seizure case from the 1950s. To which my response is, I think if you go back to Youngstown, the propositions put forth by the Supreme Court were not that shocking or surprising. The arguments made by the administration in defense of it were really that Congress had in large measure either authorized or certainly had not prohibited what the president had done. And the steel seizure decision, especially Jackson's opinion, which laid out the basic framework that a president has a certain set of powers when Congress has not spoken. And we could call those inherent authorities if you wish. And I happen to think those are quite broad. But that once Congress has legislated under its sweeping Article I powers, then the president is significantly limited. And the issue is really principally, has Congress appropriately acted under one of its powers? And then only, is there some absolute core function that's being interfered with? A very small category. That framework was accepted, I think, until a series of memorandums were published by this administration, beginning with the torture memo, which did not cite the Youngstown Steel case in a lengthy opinion, and which had as its basic move a conflation of two very different concepts using the same term. They took the term inherent power, which could mean everything a president can do in the area of national security if Congress hasn't spoken. Again, that is, in my view, a very broad category. I would be hesitant to find that a president in the area of national security was acting, as corporate lawyers would say, ultra vires, simply beyond his jurisdictional authority. It's a very different thing to take that and say, well, because it's the inherent authority of the president, well, then, of course, Congress can't interfere with it. That's got to be wrong. That second category is much narrower. And it's confused people, even like Chairman Specter thinks that if it's within the president's power under Article II, that means Congress can't regulate it. That is, I think, a fundamental error. And just give you one example close to Hamdan. And then I'll, I think, yield and move on. The one example is this. If Congress had never acted, surely the president as commander-in-chief has as part of the inherent authority that goes with that responsibility the authority to discipline the military forces and to set up a system for disciplining those military forces. In that sense, I would call that an inherent authority of the president's commander-in-chief. That doesn't mean that the Uniform Code of Military Justice has been unconstitutional and its predecessors for 200 years. So of course Congress can, once Congress has acted and addressed the subject specifically, the burden shifts tremendously, I think, to demonstrate that the president has authority to act notwithstanding that. Now, there are certain categorical areas where those of us who've been at OLC think, although the intrusion might seem quite minor, it is definitive. I don't think Congress can tell the president that you cannot nominate someone to be the trade ambassador if that person has been represented a foreign country within the previous 10 years or whatever. There are just a number of those things where the president has the power to nominate. It's up to the Senate to confirm or reject. Congress can't tell the president whom to nominate. I think there are areas of presidential authority, and there are certainly things that are in the core of the president's duties to his office that can be interfered with. But I don't think any such showing is made. So I think the assertions made of presidential power in a series of memorandum were unprecedented in the sweep of their claim of presidential immunity from having to comply with the law, and that the court's repudiation of that, even in just a short paragraph of Justice Kennedy's opinion, that what the president may do in a legislative void does not tell you that what Congress has done is invalid when Congress chooses to act and to direct the president in his exercise of those duties. And the fact that even in the circumstances of 9/11, the court was willing to say no to the president and to interpret statutes to resist the invocation to interpret statutes to give the president maximum flexibility really was historic. It was historic because of the power of the contrary claims that had been made through the Office of Legal Counsel and by the president throughout this administration, and the rejection of that approach to analysis, I do think, makes it historic.
Okay, thank you. We're going to go to Hardy Vieux next.
Thank you. Stepping away from the sort of constitutional import of the case, as a military or former military lawyer and a person in uniform, what struck me was that the JAGs were recently summoned up to Capitol Hill. That's the senior military officers of each of the services, legal departments, and they were all unanimous in their sentiment that what Hamdan means to us is that our system does work, our system being the Uniform Code of Military Justice, and that the system not only does it work well, but it's in place not just to protect, to put these sort of federal district court type procedures in place, as some people sort of lament, but it protects them, but also more importantly protects us, and that is when our servicemen and women are overseas and find themselves in harm's way and captured in situations that they're facing charges. We have a system that everyone has agreed to that is fair and impartial and works well. So when we talk about where do we go from here after Hamdan, as military lawyers, we say that the starting place is certainly the Uniform Code of Military Justice, and I would say that the ending place ought to still be something along the lines of the Uniform Code of Military Justice. I mean, our system has already tweaked the federal district court system. I mean, we have certain procedures in place that adapt to the necessities of battlefield conduct, and those tweaks already can easily be applied to the context of military commissions. One of the things that we've heard a lot about is if you have classified information, we don't want to be in a position where we compromise national security by sort of parading this information out to a detainee and his or her attorney. But again, we have procedures for that. I worked on my last year as a Navy JAG officer, I did strictly national security cases, which meant I was never seen or heard. I was, stuck in what's called a SCIF, secure compartmented information facility, and I spent lots of time there. I walked in with a notepad and didn't walk out with a notepad ever. Basically, what I learned, what I knew, what I saw, it was all in that room, and it stayed in that room, and it was made clear to me before, during, after that, if I shared anything that I learned in there, my career in the law would be very, very, very short. So, but I understood that, and I was able to represent my client. Everything was filed under seal. The judges had to be what's called read in into to the system, and read in basically means getting a security clearance and given the sort of debrief about the kind of jeopardy you're about to put your life in. But we all played by the same rules, and to me, and at the end of the day, my client actually, I think, got a pretty fair, he got convicted, but he got a fair sentence, I thought, given what took place. And so the system to me does work. Does it need to be adjusted? Yes. What Hamdan and post 9/11 tells us is that the playing field may have changed, but the basic rules do not, and that's the rules of fairness. That's what sort of got the republic to where it is today. But we'll need to make adjustments. We have things like Article 32 in the Uniform Code of Military Justice, which is loosely sort of the military's version of a grand jury proceeding. And that's probably not workable in the context of military commissions and Al-Qaeda. We also have procedures where you as a defendant are able to request an individual military counsel. That is, you can ask for a specific lawyer who's in uniform to represent you, even though he or she is nowhere near your geographic locale. Again, that might be something that needs to be thrown out. But what gives us pause from the military perspective are the sort of trust us attitude that the administration has had, and that is, trust us. We have lots of evidence that we can't show you, Your Honor. We can't show the defendant. We can't show the defendant's lawyer. We also have hearsay evidence, which traditionally is unreliable, but trust us. It's reliable in this case. And trust us, defendant. Even though you can't attend, trust us. This is going to be on the up and up. I mean, that to me is I'm not sure if stacking the deck quite captures it. I mean, that's, we're shooting fish in a barrel, and then you can lay out all the other platitudes you want. But that, to me, suggests that we're concerned about the fairness or the efficacy of the system. And I didn't know too many attorneys who've been in the military who would say to you that prosecutions are rare and far in between. I mean, that just doesn't happen. As a defense attorney, I'd be embarrassed to tell you about my win-loss ratio. And it's because, the system works and the prosecutors make sound judgments beforehand. And so you have a system in place where the prosecutors can feel confident that they got a reliable, fair verdict. And as a defense attorney, you too can take some solace, at the end of the day, knowing that that you had an opportunity to put on your case. And the way we have the military commissions currently set up really doesn't even come close to that. And that's why I think you have all of the JAG speaking with a unanimous voice that this can't stand the way it is. And we already have what the international community views as the gold standard, and that is the Uniform Code of Military Justice. In terms of deviations from the Uniform Code of Military Justice, a lot of us are of the mindset that the president, of course, should be allowed to deviate from the UCMJ, but the deviation should be narrow, they should be specific, and made with particularity. That is, the president can't just simply wave a magic wand and say, again, trust me, we don't need to have all of these protections in place. That needs to be on a case-by-case basis. And then that should be given to Congress, and Congress should have an opportunity to pass on the propriety of those deviations. And in the system as we have it, we don't have that. And the other thing that we propose is that there be judicial review of these deviations, that when these determinations about particularity are made and the president says, I can't comply with the Uniform Code of Military Justice here because it's not practicable, that we have a system where the judiciary can step in and review those decisions for abuse of discretion, or we can have an extended discussion about what the appropriate standard may be, but that there is a role for the judiciary in making sure that the checks and balances are in place and that we don't simply have a system where it's extremely one-sided. That doesn't build confidence. In fact, it seems to suggest that we're here to ensure convictions, and I would suggest to you that I think we're here to ensure fairness. And so those are some of the lessons that, as a JAG officer, I take away from it, and I'll say more about that later.
Okay, and I think I forgot to mention, before we go to David Rifkin, that he's also spent quite a bit of time in the executive branch in the Reagan and Bush 1 administrations as Deputy Director of the Office of Legal Policy in the White House Counsel's Office and in the Office of the Vice President. David Rifkin.
Catherine, thank you. My two colleagues have sort of covered two distinct aspects or implications of Hamdan, the constitutional one in Walter's case and in Hardy's case, sort of the procedures and the approaches for military commissions. I'll try very briefly to tackle both. Let me surprise perhaps some folks here with how mellow and agreeable I am today. I actually agree with Walter that the implications of a decision are probably as he describes. I'm somewhat compelled to say of all that that's not what the opinion actually says. What the opinion actually says, and I'm sort of pregnant on this issue, having written an op-ed for Wall Street Journal the day after the decision, it's a very modest, I think it's a wrong opinion, I think it's an appallingly bad opinion by the majority as a matter of appallingly bad statutory interpretation. Some of us, including Walter and partly Hardy as well, practice law for a living and do a lot of regulatory and statutory interpretation and analysis in the D.C. Circuit and various other places, and I do, and let me assure you, we can get into detail. The way this majority parsed Articles 21 and 36 of UCMJ is bad, and the reason they've done that is because they wanted to come out where they came out, and it was very, very frivolous and bad statutory interpretation case. But to paraphrase, the famous dog that did not bark. What this opinion did not do, it's very sweetly noticed that they're not reaching the question of whether a president had inherent power that would override, even in the context of a Youngstown sheet and tube case, override congressional exertions in Article 1, because the executive branch never urged those arguments. I can quibble as to whether or not the court should have reached those arguments to respond to, but they didn't. Another thing that strikes you is what this opinion is totally bereft of, is suggestion that any structural limitations on the ability of a national government, as reflected represented by the two political branches, to do pretty much anything they want when it comes to military commissions. There's no discussion of equal protection clause. There's no discussion of due process. There's really no discussion of any penumbra emanations from the Bill of Rights. Basically, the message from all justices, exception of Stevens, explicit and implicit message, you go fix it. And the reason the court did not like, at least from a technical perspective, its military commissions, is because they flout said Article 21. And it's interesting to get there, and it just shows you various tergiversations they've gone through. They deployed the international law side of things, the parsing of Common Article 3 of Geneva Conventions of 1949, without ever reaching the question, some of us are grateful for that, whether or not those conventions are self-executing. And the way they brought Common Article 3 is by the old device of legislative incorporation. They concluded that Congress, in its infinite wisdom in using the words law of war in Article 21 of UCMJ, meant to incorporate the court's interpretation of what the laws of war mean, at least as applied here, through the medium of Common Article 3. So there's a lot of bootstrapping, a lot of discussions, a very bad statutory analysis. Walter is right, nothing about the Constitution, no suggestions that the two political branches cannot do pretty much whatever they want here. And very importantly, in my opinion, the court really went out of its way to suggest that Congress should become involved. If anything, and again, let me strike you, ladies and gentlemen, as counterintuitive, if any branch, to use a colloquial expression, gets dissed, it's not the president, it's Congress. Because what the court has done, they wagged a finger as a pedantic schoolmaster and said, not good enough. What you guys said in Article 21 and Article 36 of UCMJ doesn't really address those issues the way the president claims they do. Come back, do it again. If I were a member of the legislative branch, I certainly would value my ability to come up with general statutory language broadly laid out to give the executive an opportunity to tackle it. I would not want to be always held to come back, do it precisely, do it again, do it tomorrow. So I know you really had your mind focused on it. Now, that's at least what the court has done. And the last thing I'll say on that, it's an interesting, again, whether it's a glass half full, glass half empty, even within the context of all those cases. Between the Hamdi/Rasul decisions of 2 summers ago and this decision, the court has basically validated the key features of the laws of war paradigm that the executive has chosen. Quibbled about some details, and in Hamdi they talked about, gee, the Fourth Circuit is wrong, it's not some evidence, it's some credible evidence. And here they don't like the way the president, promulgated procedures for military commissions. But these are important issues, ladies and gentlemen, but secondary, tertiary issues. They basically affirm that this is an armed conflict, but the laws of war apply, that you can detain captured enemy combatants for the duration of hostility, that military commissions are part of our law, that there is a separate subset of the laws of war that applies to unlawful combatants. But on the front end, this was an issue in Hamdi, at the front end, per Connor's plurality opinion, it's a Connor, not Scalia, the only extent of due process to which you're entitled to is a modicum of due process, something similar to Article 5, to challenge your status classification. Big set of agreements among all branches of our national government. Now you can ask me, what's the big deal? Well, the big deal, if you look at the criticism leveled by much of the rest of the world against us, it's a huge deal. Much of the rest of the world does not think it's war, does not think that laws of war apply, does not think there's such a category as unlawful combatants, things that must be somewhere. The only question is, Don Rumsfeld or Paul Wolfowitz that invented that term. And the guys we capture and hold in Guantanamo should be treated as criminal defendants. So compared with that universe of criticisms, we have a remarkable unanimity. A couple of other points briefly. But fundamentally, this is all interesting. As technicians, we can talk about it and spark. But Walter's fundamentally right. This is Supreme Court signaling in a very political manner, but they don't like what the executive branch has done. I personally think that the executive branch's bark in this administration has been much worse than its bite. Its bite has been very modest. I would challenge anybody to prove to me, and the perfect sources, you mentioned late Chief Justice Rehnquist. It's a wonderful book called All Laws by One, a wonderful treatment of all the wartime presidencies. I challenge anybody to show me how this administration has done more in wartime than not just Lincoln, but the Roosevelt and Woodrow Wilson. It hasn't. But it used some bad bark. And the court wagged its finger and used this very disingenuous statutory interpretation to say, I want to get Congress involved in that. And Congress would get involved. Whether it's a good idea or a bad idea, I don't like to see courts act politically. I don't like courts engage in disingenuous interpretations of statutes to get a point across. But quite frankly, I'm glad they did not, cobble it to some evolving standard of, of some provision in the Bill of Rights, because then you really would have nailed this issue beyond the reach of the political branches. Very briefly, and I hope we're going to get into this issue, I fundamentally disagree with Hardy in one important respect. We may not come out this in a different way as to the details of those procedures. I never served in the military, but I consider myself a student of the laws of war. I worked on those issues in the government, spent now well over 12 or 14 years studying it and writing about it. To me, there is a fundamental symbolic proposition that we cannot lose sight of. The way society treats different types of issues and offenses is not only shaped, ladies and gentlemen, by fairness and due process of the accused. It is shaped by that, to be sure. But they're also a matter of passing a judgment, at least in toto, as to what kind of a problem you have. That's why we don't have juvenile offenders, no matter how horrible the offenses, try for adult criminal justice system, because we as society want to say there's something different about juveniles. And there's something fundamentally different about unlawful combatants, which is a category that goes back to the 1500s. It was not invented in this administration. There's a fundamental difference between an honorable soldier who's gone astray and done some horrible thing, if it's true, about Hadifa, or the rape of this 15-year-old girl, if it's true. That person should be tried by courts-martial because he or she are fundamentally honorable combatants and deserve to be treated for that system. Unlawful combatants, to begin with, are fundamentally different. They can do nothing right. Everything they do is inherently wrong. They have no privilege to use force. They are a scourge of humanity, and they should be treated differently, even if practical differences between the unlawful combatant level of due process and regime and lawful ones are tiny, because we are treating them humanely. We got to give them a lot of due process. Nobody suggested they should be summarily executed, as they actually were, not all that long. And the reason for it, again, is not a lack of, the last thing I'll say, not stinginess in my part about being humanitarian. To me, negating and vitiating distinctions between the lawful and unlawful combatants, given how horrible war is, and how much more horrible war is when waged by privileged belligerents who have absolutely no intention of complying with laws and customs of war. People who want to vitiate the distinction are false humanitarian, ladies and gentlemen. They're the ones who are implicitly legitimizing the kind of combat we see being waged by Hezbollah and Hamas and Al-Qaeda. So it's not necessarily whether you start from courts-martials and how you structure a deviation. As long as we agree that there have to be different regimes, because we're dealing with different types of offenses, and we as a society, as a civilized body polity, have to acknowledge that by creating two different systems. Thank you.
Okay, so we have some different perspectives here. We've heard Walter Dellinger say basically this is the most important decision on presidential powers and rule of law ever. We've heard David Rivkin say that, well, this case is really about the dog that didn't bark. Hamdan basically affirms military commissions as part of the American legal tradition, and doesn't say that Hamdan needs to be treated as a civilian and tried in civilian courts. And then we hear Hardy Vieux saying the UCMJ works. If it ain't broke, don't fix it. And, the New York Times reports this morning that President Bush feels that it is broke and we do need to fix it. So let me give the panelists a chance to respond to each other if they'd like to take that opportunity, but also, again, to invite you, if you have questions, to write them down on the file cards that have been distributed, which Justin and I believe Liz are collecting over here so that we can pose your questions to the panelists.
But listening to David Rivkin, who's served in important civilian legal positions in the government, and Hardy, who's been a military lawyer within the armed services, makes me think, as I viewed with such great admiration what the military lawyers have done throughout this period and holding very tight to the rule of law. It did make me think that there was something to the quip that for the first time in our nation's history, a military takeover of the government would move the country slightly to the left.
I did think that.
I mean, really.
We've thought about this.
On a whole range of issues. It's, I don't think that's ever been true before. I think I have a question first for David. I think this was implicit in what you said. I believe that I won't say sloppiness of the statutory analysis in Hamdan. I would say the contestability of the statutory interpretation is what makes the opinion significant. That is to say, you think the statutory analysis was pretty stupid, and yet you and I know that John Paul Stevens is not a stupid man, that there is something else behind there, and that is where the court's view of the Constitution looms. And that's why I think you were agreeing that the opinion portends a lot, even though it doesn't say as much. Am I right about that?
Well, you're absolutely right. I guess the only point I made about that, but you didn't perhaps, since I would not be particularly judicious for somebody who may have to argue in front of these guys in the near future. I think from a technical perspective, it's a bad opinion. A bad opinion is a matter of statutory parsing, because we certainly live in the name and ball. It's not Chevron, strictly speaking, because we don't have an agency interpreting. I'm used to opinions that parse the statute in a way that is highly deferential to people who interpret it. The way they parse the statute just makes you, it's like scraping the nails against the blackboard. Clearly, Justice Stevens decided, and other members of the majority, where they wanted to come out. They wanted to get Congress involved again. It was a political decision. You know what? Let me say this. Maybe politically it was a good decision. Maybe the administration should have gotten Congress involved before, and it's a good time to do it now. I'm pedantic enough, Walter, to think that's not the role of the courts in our constitutional system to be making such judgments, but they've done what they've done. I don't disagree with anything you said. I just don't like technically how it's written.
I understand, but behind that technical deficiencies, to the extent that they are there, is a sense of some judicial modesty of not deciding more than they have to.
Thank God for that.
by taking this on narrow grounds and not making the Thunderbolt constitutional proclamation, which I think is actually, quite inherent in the opinion. And in terms of its significance, it may all be statutory, but the gulf between the opinions of Stevens and Kennedy for a total of 5 justices as compared with, say, the opinion of Justice Thomas, there's a big gulf there.
Yeah,
that is, I mean, if there were a change in the majority on the court, there could be a very major shift. There is a huge gulf in terms of unilateral. So that's point number one of just a couple. I agree that the one thing the court did not do is hamper the authority of the national government to deal with the issue of detainees in pretty much any way. But it was an odd disparagement of the decision to say this doesn't really mean much for detainees, and this will be a minor fix, because it wasn't about that. It wasn't about detainees. It wasn't about military commissions. It was about presidential unilateralism and whether the president could go and make such sweeping things on his own. So that saying that, we'll get Congress to fix it and not much will have changed, my reaction is, well, there's a big change from violating the law to complying with the law.
Symbolic value.
I mean, that is not a small thing, and that is what is achieved. Finally, just a thought that in the war on terror, and I think this is implicit in what Hardy was saying. Humane treatment and fair procedures are a weapon in the war on terror. And I say that because unlike, for example, the initial war in Iraq, which could be done unilaterally and could be done even if we said to hell with the rest of the world, that's not true of the global war on terror. Al Gore made this point before the Senate voted in a speech at the Commonwealth Club of San Francisco, before the Senate voted to authorize the president to go to war in Iraq. He said, we can defeat the Iraqi army all by ourselves or with the British and a few others. We can do that. But we can't win the war on terror unilaterally because it festers in countries in the world where if hostility to us will be the festering point. We literally can't. We not want to. We can beat Iraq. But to the global war on terror, we have to have the cooperation of the countries of the world to do that. And that's why that, of necessity, has to be a multilateral process. And I think the same analogy could be done to the fact that we are forgetting how important the notion that we treat prisoners, particularly when detainees are, to a great extent, from the Muslim world, that treating those people humanely and with fair procedures is a very important part of an effective war on terror.
I couldn't agree more, and I don't think that. I mean, David you made the distinction about sort of, the fact that there are these unlawful combatants who are not wearing uniforms and not displaying their arms in public. They're using civilians as shield oftentimes, that suggests they're qualitatively different. Though I agree to you to an extent, but I'm not sure that our response ought to be that qualitatively different. I think when you set up the system that we did now, that we have now, I mean, it suggests that no problem. It suggests that the system has to be stacked in sort of a way that, because we don't have enough evidence, because we don't have what it takes to actually get a conviction. And I'm not so sure that's true. I mean, the system has worked. We've seen it worked with just terrorists in federal courts. We saw it worked with was it Moussaoui over in Alexandria. We saw it, the system work with domestic terrorism in Oklahoma City. I think the system, we're giving it short thrift here, unless the government knows something that we don't in terms of the quality of its evidence, and that opens up a whole different discussion. But I think that, notwithstanding that qualitative distinction with lawful and unlawful combatant, that the response, at least from the military perspective, is still one that needs to be of a baseline that speaks to our values and our principles, and it does so resoundingly to the international community and rallies people around us, as opposed to just causing more dissension because of the way we stack the deck.
If I just make 2 points briefly. Let's save a discussion, let's call instrumental imperatives. How do we structure the deviation from a so-called confrontation rule, which this name applies, which had no deviations in the courts-martial system or our civilian system? You are entitled to be present and the evidence against you being discussed. And by the way, it's not, ladies and gentlemen, just a matter of being present. It's a very important aspect of the due process, because if you do not know who is testifying against you or proffering evidence against you, you cannot tell your defense lawyer, even if your defense lawyer knows everything. For God's sake, this guy hated my guts from high school. I dissed his sister or something. I want to be fair, you're really handicapped. But these are instrumental issues, and we can save it for later. But I cannot tell you, and I don't know if I agree or disagree with Hardy, I cannot tell you how strongly I feel about the proposition that however minor the practical differences may be, it is essential to maintain the distinction. For reasons we don't have time to get into, but if you look at the evolution of laws of war, going back to the 1960s and Protocol 1 additional, much of the rest of the world has abandoned stigmatization and delegitimization of unlawful combatants, beginning with the national liberation movements and all this other stuff. That is insane. We have a civilization that's besieged, and I know I'm making a value judgment here, by a bunch of barbarians and bad people, forgetting the question of an individual person we're holding as bad or good. Qualitatively, we are dealing with a grave threat to everything, to civilized law and order, to democracy. It is the worst. The United States is one of very few countries left that maintains that distinction. We didn't sign Protocol 1 additional. And we just have to hew to that distinction, because for us to say, oh, we're going to treat everybody the same. Everybody's going to get the gold standard. Everybody's going to get POW treatment. Everybody's going to get courts-martial. Given where the rest of the world is, would just complete this transformation. And it would be unimaginably bad, because there's always been a connection between how people behave prior to capture and how people get treated after capture. And you can have a good high baseline of how well you treat people after capture, but you cannot completely decouple it, because otherwise you are giving up an effort to inculcate compliance of laws and customs in war and people engaged in combat, and you're condemning to death hundreds of thousands and millions of civilians, because the way unlawful combatants fight inherently is antithetical to any kind of normative restrictions in warfare. That, to me, is almost axiomatic. Only thing I'd say about the constitutional stuff, I don't disagree with Walter. One interesting point here is, though, and this case is fundamentally different than, because people frequently sweep it all together and say, well, that's going to portend for tension between FISA and NSA terrorist surveillance program. The president never claimed that he had any plenary power to disregard. It's right, the bark is worse than the bite. That any power to disregard congressional UCMJ prescription. I'm a big fan of executive power. I never worked for Congress. I worked at Justice White House Counsel's office. Walter worked in both places. But I would be the first one to say, maybe I'm to the left of my good friend John Yoo. Congress can do one thing. It can certainly prescribe procedures for trying people that doesn't invade president's core powers and doesn't impermissibly intrude them. But that's not the same thing as to say the president cannot collect battlefield intelligence. I would give Congress enormous latitude. If Congress wants to abolish military commissions in entirely, despite all my passion in defense of military commissions, they probably can. But that's not the same thing as to say that Congress can prevent the president from collecting what he believes to be a battlefield intelligence and not spying on Americans. So the details are very, very important here. And this case and the Hamdi case and Rousseau case, while coming within the national security context, really do not implicate, in a way that FISA does, a congressional effort while exercising legitimately its Article I powers to burden the president's exercise of Article II powers. And there are no bright lines here. It's a very tough call. I happen to think that in most instances these are not actually issues suitable for judicial resolution. But that's a different debate.
Okay, we have many wonderful questions here, and I want to toss out the first one for the panelists here. We have one question which is, now that the court has undercut the authorization for the use of military force as a basis for the military commissions, what do you think are the implications for the use of the AUMF as the basis for the president's authority to do other things? And a related question asking specifically in the context of FISA and warrantless wiretapping.
Go first. I'm just going to repeat two sentences I said last. This question totally, all due respect, misconstrues the relationship between AUMF and this situation, AUMF and FISA. And by the way, to be fair to the author, the administration sort of argued AUMF, and let me be a little catty. I don't know why. AUMF doesn't add or subtract anything here. Congress came up with UCMJ, and there's nothing in UCMJ that says that it applies differently in wartime and in peacetime. So AUMF here applies certainly military commissions and courts martial. Well, you can do some civilian stuff like raping somebody in Okinawa and be tried by court martial, but the bulk of it is wartime. So AUMF to me didn't add the zip here. I don't know why they used this. AUMF in a FISA context matters a great deal. Just like AUMF, ladies and gentlemen, was the pivotal argument in the context of Hamdi, where the court, also a little signaling by reference to Padilla, decisively rejected the notion that you cannot hold Americans without proffering charges, despite something called Non-Detention Act, because AUMF established that we're in a state of armed conflict. So we have to be very careful to look at these moving parts, and one decision here does not translate to decision in another context.
The point is really quite simple, and the authorization to use military force is invoked in these debates only by those who appear confused into thinking that if the president was authorized to do it, then you don't have to worry about a congressional restriction. And I think that there's nothing that the authorization to use military force, other than that it may have legitimized sending the troops into another country. But in terms of the ancillary uses, there's nothing I think that the authorization bill of force would do that his authority as commander-in-chief or other inherent authorities would not have already allowed him to do, as against the claim that he simply had no power, that the duties of his office did not include the jurisdiction, as it were, to act in a certain way. I think the commander-in-chief clause and the take care clause and AMFU adds nothing to it, but if it was standing alone, it would do it. That doesn't answer the question of whether Congress can then come along and adopt procedures and restraints, determine the methods of detention, for example, or the kinds of, that is a very different issue, and the authorization does not get you as far as some of the invocations of it led people to think.
Okay, here's another question linking this issue to another story from the headlines, the war in the Middle East. Is there the potential that the new war laws paradigm introduced by the Bush administration and validated by the Supreme Court could influence or act as a precedent for international law tribunals in dealing with situations such as those between Israel and Hezbollah or in Darfur?
That's a good question, actually. And I like to ask it rather than answer it.
Well, I mean, again, this is sort of a bugaboo of mine, but I tend to think that law can be a good thing, can be a bad thing. Imposing requirements to comply with law in context of warfare is an ages-old quest. Is a good thing. Unfortunately, and I'm not the one who coined the term, is a term people use called lawfare. We're using the law actually as another tool in your chest of asymmetrical warfare, where you actually use trumped-up war crime prosecutions or rules that uniquely benefit rebels and whatnot, and disadvantaged law-abiding military as a way of offsetting otherwise formidable military superiority. I mean, it's actually interesting. The threat of wartime prosecutions really, not only at the national level, matters. One small factoid. Have you all noticed what was the context for the famous John Yoo memo? There's a question, if you look at the front page, whether or not people might be liable to prosecution in the War Crimes Act. And have you all noticed what was the context for an opinion memorandum issued by Deputy Secretary of Defense England on July 7th, within a few days after the Hamdan decision? The impetus for that is quite widely described in the media. The impetus for that memorandum is the fear that Defense Department personnel be subject to war crimes prosecutions for failure to comply with Common Article 3. Now, you tell me, is it a good thing or a bad thing that the world's most law-compliant power structures its thinking about those important legal issues for the prism of fear of criminal prosecution? I would submit to you it's both good and bad. If you really believe that we're not law-compliant at all and you need to sort of enhance the, like in a corporate environment, you have a rogue CEO, a rogue corporation, you want to enhance the law compliance in securities area, tax, or worker safety, that's a good thing. If you think we're already doing a lot to comply, to jazz it up to the point where a head of office of legal counsel is writing a memo, the first paragraph, the question is, how do we make sure, how we draw the lines so future administrations do not prosecute people in this administration on the war crime statute? That's not a great thing. I would think the great issues of national security and law should not be looked through a prism of criminal prosecutions. But maybe I'm wrong.
Okay, another question about these first couple questions are really about the implications of Hamdan for other contexts. Here's another one along those lines. The administration says it would like to close down Guantanamo. Meanwhile, increasing numbers are being detained in Afghanistan and Iraq. One advantage to Guantanamo has been its accessibility to press and attorneys and the jurisdictional matters decided in Rasul. Is there anything in Hamdan that would compel the military to have any system for hearings or tribunals for those in Afghanistan? If so, must detainees there wait until there has been such a proceeding before seeking relief in U.S. courts, or may such a detainee ever seek relief?
I mean, I don't read anything in Hamdan to say anything besides the very narrow holding that applies to the detainees at Guantanamo Bay.
And Guantanamo, I mean, I think the whole creation of Guantanamo was beside the point, right? They might as well have had it at Fort Bragg.
Could have been anywhere.
Because as it turned out, the court didn't buy the notion that this wasn't the United States.
Right.
So the whole idea of it using Guantanamo, and I never thought that the court would buy the Guantanamo theory because of the simple question that wasn't asked at oral argument. I would have asked the government, if you say this is not the territory of the United States, was releasing it for 99 years, and what would be the government's position if Hamdi applied for habeas corpus to a court in Havana and it was granted? Now, were you recognizing that the Cuban courts have authority over this? And if not, what is the argument this is not the United States? So That's beside the point. Though I think at the end of the day, the very important point David Rifkin made is there are few constraints that we have seen that Congress could not overcome at the president's request by legislation in all of these areas. Though there is certainly a suggestion that if you try to cut the courts out, the statute is going to be construed to say it doesn't, this statute does not mean what these words appear to say.
I cannot agree.
Yeah, I fully agree.
I cannot agree with Walter anymore, but watching them parse DTA makes you...
That's me.
Detainee Treatment Act.
Detainee Treatment Act. I don't know if you should laugh or cry. These guys really want to keep their jurisdiction. I cannot agree with you.
I think it's premature for the court to say it's unconstitutional for Congress to preclude the Supreme Court from reviewing this when they can take the statute and twist it around. I do think, David, that is a defensible judicial technique to send a message to Congress. If you want to do this, you've got to say the Supreme Court may not hear this case, and we're still going to say that's not quite clear enough. You mean we can't? Whatever. But I do think the court is, and certainly Chief Justice Rehnquist, during his time as Chief Justice, became something of a judicial supremacist. So that I've had many wrong predictions. But the day before Dickerson, I told the state attorneys general that the Supreme Court would not overrule Miranda, would strike down the statute of Congress purporting to do so, and that Rehnquist would write the opinion, which I thought was an easy call. Between how he feels about hating Miranda and its warnings and all of that on the one hand, versus how he feels about having Congress tell the court that it should adopt Rehnquist's view on Miranda, he became a person of the judiciary. And that was a very strong message of this court, and there's no reason to doubt that it will, I think, continue under his law clerk, John Roberts.
So, okay, in terms of implications of Hamdan, on the one hand, we have Scalia saying this is going to wreak havoc for the 600-plus habeas petitions that are pending on behalf of Guantanamo detainees, who now also may be exempt from the Detainment Treatment Act. But on the other hand, we have Dahlia Lithwick saying, no, this is going to do the exact opposite. It's going to push the Bush administration to move detainees into secret prisons, use extraordinary rendition, more frequently to outsource torture and other forms of abuse. Here's a question that says, well, what about Guantanamo? Rasul famously left the door open of what substantive law applies on Guantanamo, whether, for example, detainees can claim federal or constitutional rights. Do you think Hamdan will have implications for this debate?
Certainly so. I think Hamdan would have some implications, but, as I read Hamdan more and more, I'm convinced that it says less and less. If you asked me when it first came down on the 28th, I'd be like, this was great news. It's going to have wide-reaching implications. And then I read it again, and I say, at the end of the day, I'm not sure the Bush administration has to lose all that much sleep over this. And I'm not so convinced that renditions are going to increase. I think the Bush administration simply goes back to Congress and says what it says today with the Attorney General saying, look, why don't you just take our system from before and just go ahead and stamp it, and we're all good to go. We can get about our business of fighting, the war on terror. And, when I look at the proposal that's been floated about in the last day or so, it, I think, is essentially what I saw a few months ago. It's really the same proposal. So I'm not sure that Hamdan, was it you, David? Somebody described it as an irritation and in an op-ed piece, and I think that's probably right. It was an irritation, and its implications are not going to be as far-reaching as some of us hope it would be as we think about this and we go down the line.
Or military commissions.
No, right, for presidential power.
The notion is, even if Congress enacts a statute trying to track every comma of exactly what the administration was doing with detainees, the difference between a system where a president can do this on his own, where Congress is arguably at least not authorized that, and where you could read that it has come to a contrary position in the Uniform Code of Military Justice and other enactments. It is huge in the midst of the war on terror for the court to tell the president, you have got to engage Congress in this, even if it's a compliant Congress on the substance of the issue.
Once again, I agree with Walter. This is actually the relationship to what I call the front-end issues, which is certs, CSRD, combatant status review tribunals, and habeas petitions. I could tell you that as a technical matter, all that the court said in Hamdan, as per Connor, is something similar to, I'm a more precise quote, to Article 5. I don't know if Artie agrees with me, but I'm told by my military friends and colleagues that certs, the institution that sort of formalized the status review procedures, and again, remember, ladies and gentlemen, that's not a criminal process. It's almost an administrative law thing. It's challenging your classification as enemy combatant. Not only it's compliant with Article 5, it's not common Article 5, it's Article 5 of Geneva Convention 3, it's based upon Part 190 in the manual, and it does more than that. So in the pre-Hamdan world, I would have said very bravely, good enough. Pregnant on this, I happen to think it's not good for Congress. It gives Congress both a power and opportunity to shape what otherwise executive would do on his own, but it also requires Congress to go back again and again and again to the same set of issues. How it's going to look like in 20 years, I don't know, but that's clearly the implication of response to the first question.
One of the things that John Yoo says fairly repeatedly, and I've known him for years, I should have sent him an email, and he keeps saying that the Congress is now going to have to go to the trouble to overrule the Supreme Court's Hamdan decision, when what they're doing is complying with the Hamdan decision, not overruling it when they enact a law that would, authorize these activities.
Not to tell stories out of school, but John Yoo is a law school classmate of mine, and in our third year when a bunch of us were taking a human rights clinic with Harold Coe, who was teaching the clinic, Harold said, well, why isn't John Yoo taking this clinic? He's really interested in international law. And we said, Harold, John wants to work for the Bush administration next year, not sue them. We were suing the Bush administration and then later the Clinton administration for the detainment of Haitian refugees on Guantanamo. Okay, another question about the response in terms of working through Congress. Do you think the administration may be trying to run down the clock by stalling, and if Congress passes a law they don't like and they don't enforce it, the administration can wait until the composition of the Supreme Court changes?
No need for all that. No, I don't think they're doing that at all. I think they're aggressively out front, and as I understand it, that they're sort of co-opting the JAGs right now in terms of the proposal they have. Maybe co-opting is a loaded word, but there's no need for them to wait for the composition of the court to change. I think that they're out front on this, and from their perspective, rightly so. They're going to frame the debate and turn it over to Congress. They simply need to make that pit stop, as David said, and they're good to go, constitutionally speaking.
One interesting thing, and it has nothing to do with this case, what a Sisyphus-type task it is to try to change the composition of the Supreme Court. It's like the Holy Grail. You look at it for the last 30 years, it doesn't change. My theory is that it's virtually impossible to change because as some people retire, if you bring somebody who's far more conservative, that impacts the behavior of other justices. I mean, I don't think you can look at evolution of Kennedy's behavior without appreciating that he may have not evolved this way if you had a different composition of a court. And this is not any kind of disrespect to Justice. There's a lot of interactive stuff here. I don't think that Justice Stevens would have ended up where he ended up if you had a different composition. So let's not worry about changing the composition of the Supreme Court.
Okay, a sort of technical question here about someone who's been following the House Armed Services Committee hearing today on Capitol Hill. One concern was that at what point do terrorist detainee rights attach? Do these rights attach the moment he's seized on the battlefield and brought into custody? Please comment under the UCMJ as it stands and under the law as you think it should be structured.
That's already got your name on it.
The rights would traditionally attach even well before the person's even charged. I mean, in the UCMJ context, I mean, once you're talking to that person, there's sort of a target. You're giving out their Article 31 rights, the Miranda warnings, if you will. So the rights attach early. In the context of military commissions, I think the argument has been, well, they certainly don't attach that early. It doesn't make sense. It's not practical for it to attach early. So I can't really answer the question of, in the military commissions context, when they attach, they certainly attach much later than they do in the court-martial context. But we give it early, the military justice system, in some sense, front loads a lot of the rights, and we can argue as to whether that makes sense or not. But the Article 31 rights and the Article 32 grand jury proceeding, all that takes place very early on, so that a lot of these issues about procedure and what the service member is entitled to are resolved right up front.
Hardy, can I ask you a question? Isn't it the case that capturing somebody and detaining a person is primarily motivated by the age-old desire not to have a person return back to combat? That's not, even with unlawful combatants, it's not punitive, it's not penal. Vast majority of those people would never be charged with anything. So it's no different than a POW. So there's no impetus to do an Article 31 or anything, because you may just hold them and, like with Tipton guys, and send them back to drink beer 2 or 3 years later.
Exactly right. I think a couple weeks ago, Senator Graham asked the question to one of the JAGs that, well, isn't it possible that you can prosecute, you can charge and take a detainee to a military commission, have that person acquitted, and still be able to hold them indefinitely? And all the JAGs agreed, well, of course. So, that, of course, erodes the argument made by some that, if you get an acquittal, you're going to have to, release them onto the battlefield, thus jeopardizing national security. But you're absolutely right that that's the way it works.
A couple of questions here specifically for David. Let me just throw a couple out here. Are you suggesting that Common Article 3 is not part of the law of war? If so, what's the basis for that position? And then regarding your comments about juveniles, why should that not apply to juveniles at Guantanamo? They're being held and tried in the same fashion as adults.
Well, a couple of things. First of all, a pedantic answer is that the court never reached the question of whether or not Geneva Conventions of 49 are self-executing. What does it mean, not self-executing? What it means, ladies and gentlemen, it has no domestic legal force. It would be really difficult. You have to overturn a lot of case law dealing with other issues to find that this is self-executing. Point number one. Now, let me not be weaselly and hide behind the technicality and answer the question. Do I think that Common Article 3 applies to unlawful combatants as a matter of good interpretation of Geneva 49? No, it doesn't. The reading of Common Article 3 is so damn strained. I mean, yeah, this is really a conflict not of international nature. But the other thing that just shows you how silly it is, if you look at the language of Common Article 3, the triggering clause, anything else aside, so it's not a conflict of international nature, it has to occur in the territory of a high contracting party. One of the high contracting parties. Okay. Do you have Common Article 3 in front of me? Am I misstating it? Does that not the clause that leads into all provisions? My view on that is because there are some parties that have not, some countries that have not signed Geneva Conventions of 49, we have a somewhat silly result that if we capture Al-Qaeda in one country that is a high contracting party, then Common Article 3 may apply. But if we capture the same guy in a different country that's not a high contracting party, that would not apply. No. I think that as a better interpretation of international law, Common Article 3 was not meant to deal with this issue. And if you look at there are wonderful articles written about it, law review articles by people who are far more knowledgeable about the, a preparatoire and all those other things that went into Common Article 3, would surprise the hell out of those people. Now, doesn't mean that unlawful combatants are not covered by law, that they live in a law-free zone. They're just covered by pre-1949 law, which is alive and well because international law of war is much bigger than 1949 convention. It's not alpha and omega. What was the second question?
The part about juveniles on
juveniles. Look, under laws of war, I'm trying to hoist me on my own petard. Look, in a law of war situation, if you have a juvenile who became a combatant, I'm not sure that the imperative of treating a 14-year-old combatant differently from an 18-year-old is as pronounced as in the context of the domestic criminal system. But maybe we should. I'm really not trying to pass a definitive judgment on that. But that, correct me if I'm wrong, Artie, that's not been traditionally the case. I mean,
no.
Whether you were 14 or 25 didn't make a difference. Now, if you're 8 or 9, I don't know. But that's maybe so.
Another question here about the Geneva Conventions. Seeing that today's warfare consists largely of unlawful combatants, at least in this war on terror, and the spirit of the Geneva Conventions is to protect those on the battlefield and facilitate reciprocity, how do you justify excluding unlawful combatants from protections of the Geneva Conventions.
Can I add to that question by putting it harder to David? You know, it seems to me that you have this very quaint idea, not necessarily wrong, but this quaint notion that, you know, we used to do war the right way. You know, there was a law of war, and you had a clear distinction between combatants and non-combatants, and combatants were treated honorably. You know, they recognized each other as fellow soldiers across the trenches, and you had all of these protections and treatments, and that it's only because you wore the uniform and were subject to military discipline that you were entitled to all this, right? And if you were outside that, you fell outside the protections of what was, it's not the Marquis of Queensberry approach, but there was we do war, but we do it with with the right way, without civilian involvement, and the two sides meet each other on the battlefield, and they exchange all these swords, and they get protections, and when it's over, they have a signing treaty, and they have tea, and there are prisoner exchanges, but the question seems to me to be such a good one that we have self-interested reasons, as John McCain keeps insisting, that we want to set a standard for how our captured people are treated. And if that searching for reciprocity is what this is about, the idea that you're now almost going to render the Geneva Conventions irrelevant, because we're in the modern world not going to be dealing with the French army and the German army facing each other, under a certain set of rules.
Walter makes the best arguments. Let me go first so Van Hardy can beat me up. This is the first time I really fundamentally disagree with you for the following reason. Look.
It was a question, not a statement.
All right, okay, in that case, I'm sorry, but the implication of that question, at least, to be fair, that there are some quaint, pedantic rules that if we dispense with them, I'm sort of speaking as if I loved the age of writs. If you didn't plead the replevin correctly, you would get thrown out. And there's sort of a military side of it. Look, if people didn't wear the right shoulder boards, maybe they should not be entitled to the protections. That's not the case. I'm prepared, and I think people who are looking at it are all prepared to say we can be flexible. And by the way, there's already been a big change. Instead of there's a famous 4 criteria which we sort of alluded to: discernible uniform, bearing arms openly, discernible chain of command, which you need for command responsibility purposes, and institutional commitment to comply with laws and customs of war. It used to be 5th; you had to fight on behalf of a state. That's gone. But what these 4 principles reflect is not some legal pedantic stuff. They reflect age-old effort to impose some restrictions in combat, some restrictions, and there's a meaningful difference, ladies and gentlemen, between collateral damage, horrible as it may be, especially in a situation of urban combat, and no restrictions at all, no effort to limit civilian damages. To me, to sort of throw up your arms and say, well, all those things don't matter because they're not really being complied with, would kind of give up the application of law to the sphere of human activity where law is most needed. That's point number 1. So we have to preserve that, especially, I would argue, at the time where it's being so widely disregarded. Now, one thing, with all due respect to John McCain, whom I tremendously admire otherwise, it's rubbish to talk about how our POWs would be mistreated. Our POWs, ladies and gentlemen, have not gotten benefit of Geneva protection once since Geneva Conventions of 49 were done. They didn't get it in Korea, did not get it in Vietnam, did not get with 2 or 3 people who were captured in Kosovo, did not get them in Gulf War, because we had some women who were actually sexually assaulted and raped, and male prisoners were brutalized, and God knows we're not getting that for people in Iraq or Afghanistan who fall captive to the enemy. So let's not talk about reciprocity. The notion that the headcutters and the torturers who dismember people when they capture them are going to be motivated to behave better if we accord them Geneva protection, to me, is laughable. So reciprocity does not work. Doesn't mean we should do horrible things, because I think all 3 of us agree we should do the right things to be true to who we are. But let's not be hasty. Let's not give everything in the kitchen sink to the unlawful combatants, because we're not going to get any reciprocity. And again, on reciprocity, am I wrong? Have we ever gotten Geneva protections? Has Mr. Nasrallah come forward, or Osama bin Laden, and said, if you treat my guys as POWs, maybe I wouldn't cut the heads of your people when I capture them? They never said that. They would laugh. They think all that stuff is crap. The laws of war. Mullah Omar said, even before September 11, this is old Judeo-Christian stuff. We'll reject it. So it's not about reciprocity.
So from an enlightened self-interest standpoint, is there a reason for us to have our own normative standard? I mean, would you just say that that's sort of a quaint notion as well?
No. On the contrary, I think we should have reasonable standards, because there are many things I've never, whatever it's worth, I never supported torture. I never supported inhumane, degrading treatment, because we cannot do certain things as civilized society without losing our heart. To that degree, I agree with the critics. But it doesn't mean you got to kiss them on the head and give them a cup of tea. It doesn't mean you shouldn't yell at people and put a little psychological pressure on them. To me, this is the classical slippery slope versus absolute arguments. No, we have to be. But seriously, Walter, maybe I got the question wrong. Does it not make sense to try against hope, against everything that is happening, to retain the notion of some normative restrictions on warfare? Are we going to say, look, you're right. The questioner is right. 99% of people are fighting against unlawful combatants, killing civilians by the bushel, hide among civilians. So what? Do we give up? Do we become like them? No. We have to do something, but it doesn't mean, again, we have to give them everything. And we have, the last thing I'll say, we have a very strange thing. The rules always favored law-abiding states and disfavored the rogues and the bad guys and the brigands and the pirates. We now have all the rules that do nothing but constrain law-abiding states and completely seem to untouch the bad guys. I mean, that's kind of this old song, world turned upside down.
A couple of questions about the designation of unlawful combatants. Here's a question for the panel as a whole, but says, given Mr. Rifkin's position on the fundamental distinction between unlawful combatants and pretty much everyone else, I'd like to ask the panelists, how do they think the D.C. Court of Appeals will react, ignore, or incorporate Hamdan in their pending opinion on Al-Oda, which concerns the constitutionality of the Detainment Treatment Act and the combatant status review tribunals, which are being used to evaluate who at Guantanamo is an enemy or unlawful combatant, and whose procedural rules make the military commissions look, quote, progressive. So how will Hamdan affect the D.C. Circuit's consideration of Al-Oda? Any thoughts?
Can I make a one-sentence point, because I don't know the answer, but to say, one of the things that the court has got its eye on is whatever you think about the lesser entitlement of unlawful combatants, the determination of whether a given person being held in custody is or is not an unlawful combatant, is or is not a terrorist, is a very important function, which I think Attorney General Ashcroft waved over when he said these people are not entitled to, their terrorists are not entitled to any protection. When the first question has got to be, do they meet that description or not? And with respect to that, short-circuited procedures are deeply troublesome, particularly because the people who are being held are generally of one ethnic or religious group. That is to say, somebody like me doesn't have to worry that I'm going to be caught up. I'm an obvious redneck cracker, so people don't think that I'm, actually Al-Qaeda. But it worries me a lot. It worries me in the sense of, to assume that you don't need the most careful procedures to make that determination is to make the assumption that the Supreme Court made in Prigg versus Pennsylvania in 1840, which was when determining whether someone was a fugitive slave, the most slipshod procedures would be fine. And the unstated premise was, of course, in any event, it's a black person. He was a free person of color. So, the risk factor of a wrong determination did not seem that salient to those that did the Fugitive Slave Act.
Okay.
Just one word. I agree with it, but don't just ask you all. Do you not agree that traditionally the determination of whether or not one was a combatant or not, under either Article 5 of Geneva Free or in the customary law, was not the same in terms of due process and various other things as a criminal process? The question never is, to me, whether due process is due, but what process is due. And unless one says that the court is going to flip on Hamdi, what's not due is the level of criminal justice system process, unless I'm missing something.
I understand your point. I don't think the UCMJ doesn't seem to attempt to sort of replicate the criminal justice process in its every step along the way. So I don't go that far. I'm with you there. But I stop short of saying, well, the process that we have where, you sort of, you don't see the evidence, you don't know the evidence, you can't be there. I mean, that to me says more about us than it says about them, and that's what troubles me. That's what sort of keeps me awake, that regardless whether the person was wearing a uniform or was using sort of civilians as a shield, I still think that as a defense attorney, that conviction would be something I'd be a lot more comfortable with if there was some minimum floor that we met, some minimum due process that we said, regardless of who you are, we're going to give you this. And I'm not sure that that's there. And I understand your point is, well, why put it there? I mean, it doesn't make sense to put it there given their status. But I think that says a lot more about us, and that's what I find troubling.
We're coming to the end of our time. There are a number of other really thoughtful questions about, is there some legal confusion about keeping detainees off the battlefield versus extracting intelligence? Shouldn't we be more concerned about future dangerousness rather than the past conduct of detainees? Let me just give the panelists an opportunity, if you want to take a brief moment to make any closing remarks, and then we're going to have a reception following this panel.
I'll just make a point about history, because Lincoln was often invoked as an example of a president who used sweeping war powers, and that is both a fair argument in defense of President Bush and a flawed argument in two senses. One, it is certainly the case that Lincoln took an extraordinarily expansive view of the president's authority, using his authority entirely and exclusively as commander-in-chief. He freed all the slaves in states in rebellion. That is not a small matter, totally on his own authority with the stroke of a pen. He assumed that the clause that said the writ of habeas corpus shall not be suspended except in time of surrection gave the president the authority to do that, even though it appeared in Article 1 among the legislative powers, which was also a pretty big swing. That being said, remember that this is a situation in which the enemy had shut down all rail transportation north of Baltimore, so troops couldn't get to the capital, and the enemy had moved its capital to Richmond, Virginia. Now, that's a very different context, but more importantly, when Congress came back into session on the 4th of July, 1861, Lincoln submitted all of this to Congress, and on habeas corpus, the Congress made changes in it, which Lincoln, of course, complied with. And I think he understood that deeper than almost anybody ever has, that the Emancipation Proclamation was a performative utterance, symbolism that would actually work because it would be a signal for people to free themselves. Authority didn't matter. It is really a particular case. But I think Lincoln did submit to the judgment of Congress more readily, and at least without some of the rhetoric. And you may be right about the bark and the bite, but the bark worried me as a signal to future presidents that Congress couldn't touch anything that was within the sweep of a broad range of president's power. And I've begged my friends who are more conservative, I won't name any names here, to think of their worst nightmare as president when they think about that power.
Walter, very briefly, and one short observation. I hear you, and at least I have conservative friends who always extol me to be more cautious and where I draw the parameters of presidential power because of Hillary Clinton being president. And my response to them is that I actually defended in writing President Clinton's ability to introduce troops in Haiti unilaterally because I think constitutionally, all costs of it makes no difference. What the policy motivation is, the Constitution is the same. But look, there are enough sins to go around, and in retrospect, there are some things this administration has clearly done that are wrong, particularly on the BARC side. In their defense, I would say they felt that they needed to recapture the ethos of executive power after decades, and I don't need to tell you that there's been a lot of pushback. The thing that troubles me the most in the current setup is not congressional assertiveness. In fact, paradoxically, I would like to see, and counterintuitively perhaps, said what I said before, I like to see Congress do more. The thing that really scares the bejesus out of me is not that, because the framers believed, I think, in the Constitution's invitation to struggle. It's a great term. I wish I coined it, but I didn't. And if Congress wants to overhaul the president and do it in a politically accountable fashion, that's fine. Political accountability is the most important constitutional virtue. What scares the bejesus out of me is the tendency not to use political tools, not to use oversight tools, not to use funds cutout, but try to shove everything through the prism of judicial review. Ladies and gentlemen, Article 3 has just as many limitations, if not more, as Articles 1 and 2. The notion that the courts can scrutinize discretionary actions of the president, discretion lies at the heart of executive power, again, read Harvey Mansfield and various other folks, is so bad, so dangerous, because it not only warps and corrupts judiciary, but it fundamentally enables the judiciary to do this without political accountability, because they're not subject to it. So I would not mind having Congress club with the president. If Congress wants to stop NSA surveillance, let them cut off all the money. Just put appropriations rider. I think it would be constitutional, despite the doctrine of constitutional conditions. Maybe if I would all see, I would take a different view. But you can do that. What you cannot do is have a bogus judicial review provision that gives a bunch of judges an opportunity to spike it or bless it. I don't know, no matter which way. That is what's dangerous. That's new. That never existed before. And the reason Congress is doing it, because they're not interested in doing this in a politically accountable fashion, because you pay a price for it. So that's my only beef.
I tell you what, the deference to the judicial centeredness of the congressional response, the idea, I mean, where you and I would be in linked arms, is the idea that the Senate, through its counsel, could ask the courts to pass on the lawfulness of a presidential, quote, signing statement. I mean, this is where, the OLC brotherhood says that that's got to be.
It is being done by Republicans, frankly speaking. Democrats,
It's hard to get these things calibrated right.
So much angst here. I just remember in 1998, I was clerking in federal court in Denver, and I worked for the judge that was then presiding over the Oklahoma City bombing cases. And I remember being buried under a sea of motions that, it was just day after day I got hit with all these motions by the defense attorneys. And as we got closer to sentencing, as the judge got closer to sentencing Terry Nichols, my task shifted from doing motion work to researching the crime of the crime of treason. And the judge I worked for wanted to be able to basically make the argument that essentially what Nichols and McVeigh did was analogous to the crime of treason. And I spent weeks and weeks doing this research, and the judge got on the bench and said just that. And then he went further and said, but I'm going to sleep very well this evening knowing that you filed all these motions, you asked for all these protections, and the best part about everything is that we gave you every single thing you needed. The system that you tried to strike down worked in your favor. So whatever conviction it is that you have today, whatever sentence that you get, is justly deserved because it was fair and it was the way that we do business, even though you attacked that very center. And that, to me, still resonates with me, and it very much colors my perspective on these things.
Okay. Please join me in welcoming and thanking the panelists.
I agree with you. The criminal justice system would rather let 99 guilty guys.
And there will be a reception, I believe.